Hello, my name is Cecilia from the NYDA team, and you are listening to the NYDA podcast. We conduct due diligence and monitoring of working conditions using worker engagement technologies. And on this third season of this podcast, we want to support procurement and sustainability professionals with powerful insights relating to human rights due diligence. What are the legal requirements when considered practically, and what would constitute good practice? We bring you some of the leading voices in this field to answer these important questions. Come and join us.
Good afternoon to everyone. Of course, this will be listened to in mornings, afternoons, and evenings, but hello. My name is Lee Esterhazen, founder and chief exec of NYDA. More of that later, but I wanted to start by welcoming all of you. Thanks for joining us today on another special edition of the NYDA podcast. As mentioned in our intro to this podcast series, this season of the podcast is focused on human rights due diligence, and specifically how to support procurement and sustainability professionals, but also C-level execs with embedding and acting on the 6 common elements of human rights due diligence as these appear in all the new laws. And these 6 elements, of course, the origin is the OECD Guidelines. So back to the important bit about the podcast, wanted to start by welcoming Colleen Theron, our guest today. She's no stranger to the podcast. We kind of pull her into it as often as possible. Her first appearance on our podcast was in our very first season, all the way back in 2020, the dark days of the pandemic. So thanks for coming back. And Colleen is founder of Ardea International and brings a wealth of experience in supporting brands with meeting legal requirements while also, importantly, hardwiring good practice into their operations. Colleen is widely respected for her ability to bridge law and practice in the field of business and human rights. Is the only expert I know that has expertise on the environmental law side as well as business and human rights law, and is also highly respected for helping brands to get better equipped for risk assessing and addressing, and indeed, when needed, remediating human rights impacts along supply chains. Colleen and I have always shared a few passions, one of which is addressing hidden exploitation. We both, come from a South African background, which speaks for itself, and a passion for supporting all the necessary stakeholders to increase their visibility into human rights risks and impacts, and to importantly drive material improvements where needed. We've worked together in construction in the UK and are now just getting started on another exciting program, but happy to share more on that once it's up and running. But enough from me. Welcome, Colleen.
Lee, thank you so much. It's such a pleasure to be with you again. I can't believe it was 2020 when we first spoke on a podcast. It seems like a different world ago. And yeah, thank you. I'm looking forward to our conversation. Certainly, I think in the last 2 years, we've had opportunities to share and think and debate these particular issues, in various formats and really, I guess, focus on, just how we can help and support organizations to understand what are the touch points, what are the difficulties that they are going to have to overcome to really be able to say with some confidence, we know where our risks are and we're addressing them, and we want to ensure that we don't have exploitation or modern slavery or forced labor in our supply chains. So I'm really excited to be here. Thank you.
Thanks, Colleen. Beautiful. And also wanted to just add, I didn't mention earlier, I'm chief exec of NYDA. We also involved in human rights due diligence, very much involved in risk assessing and tracking human rights, adverse human rights impacts and risks. as well as supporting brands with communicating what they find and what they're doing about it and how improvements have been made to all the stakeholders concerned. And of course, we work closely with Ardea. The topic today essentially is the brands are very used to adopting codes of conduct and rolling out compliance measures such as social auditing along their supply chains. These are the kind of often used tools in business and human rights. But the new laws demand more than that. The new laws are, interestingly, consistently based on the OECD guidelines, which go beyond, taking simple measures to demanding that brands address what they find during their assessment processes. The requirements read that companies need to cease, prevent, and mitigate adverse human rights impacts. So what Colleen will be asked to discuss and share her experiences with will be, what this means in practice, what addressing these adverse human rights impacts means in practice, and what advice she would offer to brands starting out on that journey. We've got a series of questions to guide the conversation. So let me dive into those, unless there's anything you'd like to add at this stage, Cole.
No, I think, the point that you've made about the laws that are changing and incorporating the reference to the OECD guidelines, and in fact, also the UN guiding principles on business and human rights, the frameworks that are offered by these two organizations or the principles that are embodied there. I think it's really relevant to the audience to know how much change has taken place since 2015 in the way that the laws are embodying this requirement that you actually are able to demonstrate your due diligence through a continuous process of improvement, as opposed to simply reporting on what you might be doing, which we're familiar with when we look at things like the Modern Slavery Act in the UK, or the Australian Modern Slavery Act, or the California Transparency Supply Chain Act. Those laws really are focused mostly on just a reporting statement. Some of them don't even require, like the California one, an annual update. But the laws that we're looking at now are saying you need to demonstrate this, and they are pulling in these frameworks for companies to be able to lean on and to use to be able to develop their systems so that they will be able ultimately to help mitigate risk in the event that there is an adverse human rights impact, there's litigation, or other risk issues that come to the fore as a result of what they might be involved with.
Great, thanks, Cole. So essentially, previous laws were all about saying you need to report whatever it is you are doing, just report it, versus the recent laws that are due diligence laws are far more focused on essentially a much more rigorous process broken down into a series of requirements.
Absolutely.
Great. So wanted to start, Cole, with asking you, just by way of background, which sectors is Ardea currently active in?
Well, we work across sectors. We've never limited ourselves to one, and I think that's been a real benefit for us as a business, because it means we've had the ability to gain insight across how many different organizations work in these sectors. So we've worked in agriculture, we've worked in tech, we've worked in information services, we work in sport, we work in timber, we've worked in coffee, we've really kind of construction, a lot of stuff in construction. So we've really, off the top of my head, those are just sort of 7 of the sectors. Sorry?
And tobacco, but of course, I agree.
Tobacco and agriculture. So just, a massive variety of sectors. And actually also increasingly now in the financial sector. So around some asset managers, some equity funds, we've started seeing an interest coming from them in terms of how they actually also address this from an organizational point of view, not just from a fund management point of view.
Fantastic. When you look across that diverse landscape, what trends are you seeing when it comes to human rights due diligence and responses to the new laws?
Such an interesting question. I think that, if I'm honest, there is a bit of a scramble starting with organizations suddenly thinking we need to do something and not really being sure where they start. And that's not helped by the fact that there's so much emphasis also on ESG, on the environmental social governance, sort of, I don't want to say it's a trend, but it's very much a focus by investors and increasingly by banks, and other customers, big customers asking their supply chain to be able to demonstrate, appropriate ESG strategies that will help them with their own targets. So there's a immaturity still, I think, around where's our segue in? How do we start this, and where do we go with this? And I know we're focusing on the human rights due diligence side, and I think what I see across the board is that also the drive for the change is coming from different parts of a business. So it's not always from a top management drive down. It may be that your sustainability manager or your procurement manager or your HR manager, the person who tends to have an issue landed in front of them in terms of on their desk, and then they think, oh, we've got to deal with this. They hear about the law, and then suddenly it sort of snowballs, and they have to think about how do we address this internally. So I think that there's a bit of a scramble. I think there's a shift in what I am seeing is we're doing a lot more boardroom training sessions, which is quite exciting, which means that culturally, I think that more boards are becoming aware of their own potential liability if things go wrong. So I do think that, in some areas, maybe some of the more mature businesses, there is the sense amongst the boards that they need to actually be managing and developing programs that help mitigate their risk. I'd also say one of the trends is that people have not considered what resource they need to actually get something robust in place. So I'm seeing a real scramble internally for the people that are managing this program not having enough resource either internally or spend to get the external help. And I do see that as something that's going to have to be critically addressed in the future, because nobody can resolve any due diligence, and particularly human rights due diligence, overnight. It has to be a journey, and it's going to take time. And that means you need a period of time where you're investing in change, in systems and policies and in culture, and that needs resource.
In the OECD guidelines, and it's also mentioned, of course, in the UNGPs, because the UNGPs cover these 4 steps of assess, address, track, and communicate, and OECD covers 2 additional steps. The first being embedding practices organizationally in order to deal with human rights due diligence, and the final step being ready and equipped to cooperate with remediation where needed. But that step 3 in both frameworks about addressing adverse human rights impacts. In other words, ceasing, preventing, and mitigating adverse human rights impacts. When it comes to that step 3, Cole, what should a medium-sized brand be expected to do here?
So I think that's an interesting question, and the caveat you've put on around a medium-sized brand is quite interesting too. Is that I think that before an organization can cease anything, they have to actually understand what it is that they are potentially impacting. So that step of actually getting visibility across their organization and their value chain around where they might potentially or actually impact on human rights is, I think, the really first critical step. So, a business needs to understand its value chain. It needs to understand currently what visibility it has. And if it doesn't have the visibility, it needs to think about how is it going to get that visibility. I know that's one of the things that, we've worked together on is, using worker voice to get some visibility in a supply chain around the worker's voice. And there are other mechanisms too, but I do think, that first step is really getting the visibility. And only once you know what your visibility is, and also what your relationship is to the impact, so whether you've caused or contributed or directly linked to that impact, then only can you start making some decisions around how you would cease and how you would prevent and how you would actually mitigate.
Really pleased you mentioned the visibility point, because of course diving into addressing an issue before you understand the extent and nature of the problem and your relationship with that problem is a no-brainer. And wider certainly can support in providing visibility on the extent and nature of human rights, kind of adverse human rights impacts in terms of working conditions, as well as in terms of communities along your supply chain where needed. But in terms of the kind of causal factors and where, to what extent perhaps purchasing practices have contributed, or to what extent a particular brand's demands on a particular workplace may have triggered certain strains. I do appreciate at this point that visibility, kind of the specific answer to that question of to what extent are we part of, are we causing the problem or contributing to the problem, can be a tricky one to answer. But Cole, am I right in saying that if a brand demonstrates that they investigate as far as can be reasonably expected, that they investigate what role they might have played, that qualifies as a sufficient measure?
So, I mean, absolutely. I think, what I see increasingly with organizations is that sometimes they get lost in thinking they have to address everything. And actually, the UNGP's principles are very much aligned to proportionality. And I mean, you see that in law as well. It's a reasonable person. It's what is proportionate. What is proportionate to your risk as well is how you might address that. And so, I think that that actually it is really critical for a business to also understand operationally with their own policies and their own practices, how they might be addressing to things, maybe not directly, but indirectly. So the point that I also see with businesses is that very often they go to supply chain or value chain as the issue, and they don't look at a corporate level how to address that particular issue and what that means in addressing their own policies, culture, and processes. And so, almost going back to your question, what do medium-sized, what does any business do? Need to understand, do a proper gap analysis around what is currently your operation modus operandi, so that what it is that you've got in place that might do that contribution piece, and that you might have to start working at that top level first to address the procurement practices or the contracts or the supplier codes or the policies, and then let that trickle down into the supply chain to where your higher risk areas are. Did that answer your question?
Beautiful. And Cole, is it fair to say it would be wise, when looking at the kind of corporate measures that can be taken and can contribute not to adverse impacts, but the opposite, to positive impacts and good practice, that in that contracting, etc., one should look at clauses and messaging that deals both with preventing adverse human rights impacts, but also mitigating if and when those impacts are identified.
Absolutely. And I think, the mitigation element is probably also, not massively understood. I still think there's a lot of maturity that needs to come around what does mitigation look like and what does remediation look like as part of mitigation. There's all these different elements to it. But absolutely, I mean, I think where businesses are at least starting to do something and can start demonstrating that, what they're putting in place is effective, that has to go to mitigation. Sorry, that was actually your previous question, is that, would it be sufficient? Well, if you are tackled in a court of law, it depends on the jurisdiction, the claim, what people are bringing. But by and large, when you look at the OECD framework, the UNGPs, the requirement is that you are able to demonstrate that you understand the impact and that you're doing something about it and that you actually can remedy it. And if you can prove that, there is always going to be mitigation in that. And we've seen that in the courts in America. There's a very interesting case called Barber versus Nestle, which is on our website, where, these points were pulled out. And we're seeing it more in some of the cases that are coming through the Netherlands and in the UK. The mitigation element is really grounded in understanding what you are doing to at least address that impact. And I think I just want to add one other thing around this area, Lee, is that I think that there is still a massive requirement for businesses to understand what we mean by risk to people and not risk to business, because that lens is a different lens. And we see how many businesses we work with, they haven't understood how to shift that lens. So they still see everything in terms of business risk. Now, it might be that risk to people is going to be a business risk to you. But it's that different lens which brings in the engagement piece, which brings in the trust piece. And that is a very big part of human rights due diligence. It's not that tick box. I've got a policy. I've got a supplier code of conduct. I've got 100 suppliers to sign it off. I'm all okay. That's not what the UNGPs or the OECD or anybody else is saying. That it's got to go further than that.
And Cole, won't you just give us a kind of nice, clear definition of mitigation?
So I think that what it really is about how the actions you take to reduce severity or the seriousness of something, and how you might demonstrate doing that.
Excellent. Fantastic. On to the common oversights or errors you see companies making when trying to address human rights, adverse human rights impacts or human rights risks.
If I'm honest, I think the biggest mistake I see is that organizations want to rush a solution and they end up putting a sticky plaster over a wound. And they also go to things back to front. So they don't spend time, it's that point I made right at the beginning, they don't spend time understanding where are their impacts. Also, what are their salient human rights? What are the critical human rights as a business that they should be addressing? So that goes to prioritization. And it actually goes to resource management. When you know what those key elements are, then you can manage that better and manage it better in the territories if you're a global business or where you have to address that. So I do think that rushing things, sticking plasters, resource failure, really pulling out, not really understanding the cost and the investment that's needed in this. And I keep using the term investment because I honestly feel that where organizations actually get a hold of the issues and they start strengthening their policies, their training, their processes, inevitably they are going to be a more resilient business because the other flip side of what we see with due diligence and is the reporting aspect from a corporate sustainability reporting side. As I'm not talking about the modern slavery type reporting. I'm talking about being able to report in your annual report. For example, under the Companies Act in the UK, you are obliged as a director to be able in your strategic report to talk about environmental and social impacts, which companies are still very immature about. You will be obliged under the EU to undertake certain corporate sustainability reporting if you meet the requirements. So that is, to me, the other side of all of this is when you understand what you have to do and you get your data and you determine what's material, that means you can start reporting on this effectively. And that means you can start tracking improvement and really talking about that. And so, I just think that, again, the other thing that's missing is that kind of holistic picture of where this all fits into good governance, which is a term we've not used a lot in our conversation, but I increasingly see how the governance aspect is really critical to managing human rights due diligence.
I was curious about, in the companies you're working with and alongside, who in a typical corporate is usually responsible for addressing adverse human rights impacts?
So from a governance perspective, and if you read the literature, if you read, for example, I was involved in developing a standard on modern slavery, a guidance standard with the BSI on modern slavery for organizations. The most of these standards will require that a board member will take some form of accountability. It tends to often sit with an executive member, not always with a board member, but there is that sort of requirement from an oversight point of view that somebody at board level should be able to hold this responsibility. And again, I think that's something that companies are grappling with, and they may have a sponsor on the board for climate change. I mean, everyone's doing that, seeing it, and then there's a question: is it the same sponsor for human rights? Maybe not. So I would say it really depends on how companies are set up and their size. Their size is going to impact on this, because you might have a committee within a business that's going to hold accountability for it, which might come through your operational teams or the teams that are sort of on the cold face of these issues, and then have a governance structure of how that looks. In smaller companies, it will tend to go with the supplier sustainability manager, or whatever title they might have, as to being the one that holds the environmental and the social aspects for the business.
Okay, fantastic. And now back to the practice itself of addressing adverse human rights impacts. You've mentioned, essentially the common oversights or errors made in that step. But what have you seen by way of appropriate or good practice when it comes to addressing adverse human rights impacts? And I'll ask that question broadly, but perhaps in your response, you can help us distinguish between ways in which companies address potential adverse human rights impacts versus ways in which companies address actual, materially assessed human rights impacts that they know about because they've measured them, because they've seen them on a dashboard. They're not suspecting that perhaps this is happening because a competitor has had the problem, or there's been a kind of headline.
So I think what I see in relation to the potential side is that, to me, is that initial piece, that is, where could our impacts be, and what is missing in how we currently address issues through our policies, through our processes, through our operational aspects. So so for example, better practice might be that you start developing a supplier code of conduct. Let's just take that as an example, and then there is some engagement built into that with your stakeholders. I think that's the more appropriate side as well, is actually the engagement piece, to get people to understand what you're trying to do and why you're trying to do it. I also see something that we've been doing as a business for some time is we've created a set of questions, a due diligence platform we're about to put together, where highest risk suppliers are asked a series of questions and to produce evidence of how they are complying to those. And we would assess that. And the higher risk ones, then there is an action plan of how a client might address that. So that is another mechanism of understanding potential impacts. And I guess what we're doing as well, Ardea and wider, is using, that sort of combined methodology of saying, here's on the ground worker voice insights versus, an assessment of what you are doing in your procurement practices, for example, to get that visibility to address the potential piece. And I also see that training is, to me, part of potential impact. So who is even aware of the language, who is aware of potentially the issues, who should be aware, who should be trained on that. So I would say that's what I'm seeing around the potential piece. It's that front end building and understanding. On the actual side, I think where we see good practices is those businesses that have really have started getting the data in and have started thinking about how they might mitigate the issues. So, looking at what does remediation mean? I think, again, an area that is just quite immature. And I think that's just because of how things have developed, with the UNGPs have been around for 11 years, but the maturity around remediation is still growing and very immature, I'd say. But the companies that have got a hold on this, I think, are really starting to look at understanding remediation and putting effective grievance mechanisms in place, which is not just a whistleblowing hotline. I think if there's one message I want to tell people, whistleblowing hotlines are not your solution to remediation. They're one element of it. And then I think being able to track improvement once they start, addressing those actual impacts. If we've had 100 this year, can we reduce that to 50 next year? Can we track it? Can we talk about it? Goes back to that disclosure piece.
I wanted to ask what, about remediation. Essentially, you have just provided such a perfect segue into this next topic. As you said, in your opinion, after 11 years of UNGP kind of impact, we still see low levels of literacy when it comes to remediation. Can you help us with that? Can you help to clarify when remediation is required? And let's start there. When technically is remediation required?
So from a UNGP perspective, they're very clear, the guiding principles are very clear that only in the event of you've caused or contributed to an adverse human rights impact are you required to remediate. The third element is considering if you're directly linked to that impact and whether you've got the leverage, so the power, the influence, to be able to also help address an adverse impact through remediation. And so, again, I think this goes back to what we started talking about, is that, when companies look at this without really thinking about their higher risk impacts, they do that sticky plaster thing, and then they start going all over the shop in terms of how they might fix things or not fix things, or just have a whistleblowing or speak up line, and that's sufficient. And if they haven't done the work to really understand where do they cause and contribute, and then what is most reasonable and appropriate method of actually dealing with that or a particular issue, if they haven't done that, then they're not going to be able to look at remediation in a really mature manner. So I do think that is probably the answer to your question as to where the starting point might be.
Cole, your points that you've made have been so strong on the need for human rights due diligence to start with good governance, to start with C-level literacy, to ensure that you have a clear knowledge of your salient human rights risks. Where are the areas in your business and supply chain where that saliency applies, and then ensuring that your due diligence is adequately resourced in those areas to make sure you're risk assessing, addressing, tracking, and communicating all that needs to happen. So that's been so clear. And finally, to say, if you are sourcing from geographies where there's a risk of state-sponsored forced labor, to be extra clear when it comes to your human rights due diligence. Your point, your language was enhanced human rights due diligence in those areas, to ensure that indeed when those kind of enforcement agencies come knocking, you can demonstrate and prove that you've covered all the above very thoroughly. So thank you so much, Col, for this kind of very pragmatic input. As always, it was an absolute pleasure. We look forward to working a lot more together in the future, and certainly in the area of kind of assessing and tracking human rights risks and those material risks. But love working with Ardea. The kind of wisdom that you get, when you do is always very worthwhile.
Thank you, Lee. I really enjoyed it. I love that you always challenge me with the questions and, thinking, bringing thoughts together. It's really great. And hopefully through our conversation, a lot of organizations will get some clarity as to where they should go and what they should start thinking about doing.
That's it from us today. Thank you so much for joining us. Be sure to follow us on LinkedIn to keep up to date with all things NYDA, and look out for our next installment. Goodbye.